Okay, Alexis Rosenberg and Kurt Altman are still here with me to break this down. Now, Brian Steele has argued many motions before this judge, from mistrials to having the judge recused. Many speculate that these are attempts to delay the trial. Do you think that this argument, this motion, was different than the other ones? Alexis, I'll start with you.
You said it. He's made many arguments. I am not so sure it is to delay. I think it might be for appeal purposes. But is this argument, I mean, the likelihood of a judge recusing a prosecutor, that's highly unlikely. So, do I think this is any different? No, but I think he is setting the record up for a potential appeal.
No, absolutely. You always want to have a fleshed out full record for the preservation of the appellate record if you are going to take a case to appeals, especially if there's a conviction in this case. We're going to listen to the prosecution's response right now. And then, Kurt, I want to get your take on it after we listen.
The Supreme Court case, it's 236 Georgia 507 at 507 and 508. There they approved of a jury instruction, and I will concede that it was a curative in that case, but it says that the instruction said that anything a prosecutor might say while asking questions on cross-examination was not evidence. So even if you think that was an improper speaking objection, which is not the first one we've seen, the remedy is not disqualification, which, as Your Honor is aware, is a radical remedy. Going forward to this other communication, the second major point that Your Honor had asked us to discuss, this instance where Ms. Love asked Ms. A.B., isn't it true that you sent a communication talking about the judge can kiss your ass? That's just not good phrasing. Send a communication. It doesn't necessarily mean, it doesn't say, didn't you send a text? It doesn't say, didn't you send an email? It says, didn't you send a communication? That's just kind of maybe imprecise phrasing. The remedy for imprecise phrasing is not disqualification either. And if you listen to the rest of that question, Ms. Love went on right after that, really kind of interrupting herself, and clarified and said, did you tell anyone at the DA office that the judge could kiss your ass? Did you tell anyone that? So she heard her own imprecision, she corrected it, and then the answer was no. So we had this big argument about how Bonner doesn't apply because in Bonner the witness said yes. Oh no, well in this case the witness said no. It's a question.
But how are they going to impeach her on it?
However they want. They can cross-examine her. They have the text, every single text that anybody had with Bennett. Those speak for themselves. They can cross. And the very next witness that I believe the state may call in relation to AB is going to be the investigator who was going to be present for these communications. And just to clarify, which I think wasn't.
Okay, so that was Prosecutor Dane Ulesky arguing against the removal, the disqualification of lead prosecutor Adrian Love, who was not present in the courtroom during today's proceedings. Kurt, I want to get your take on this. First, it's important that an attorney does not interject themselves into the case to the extent that they become a fact witness that will potentially open the attorney up for disqualification. Let's talk about what we just saw with the prosecution's argument against disqualification. Of course, this is Fonnie Willis's office. She was facing her own DQ motion, which was denied. And here's another one before that court in Fulton County. Kurt, do you think that the prosecution's argument was compelling? And do you think that it was potentially a bad look that Adrian Love wasn't in the courtroom herself?
I'll answer the second question first. And yeah, it is interesting. This apparently happens a lot in Georgia, as we know from recent events. I think her being in the courtroom was probably, not being in the courtroom, was probably appropriate because they're arguing about her. And so this is outside the presence of the jury. That's not unusual. I do think that disqualification is a very, very rare and extraordinary remedy. I don't think that's what's going to happen here. The judge said something very, very interesting to me. He said, how are they going to impeach this witness? And that's really what this is about. A prosecutor can talk to a witness. They can prep a witness. They can meet with a witness. But if a witness says something different than what they told you in that meeting, you have no way as a prosecutor to remedying that. You don't have another person like an investigator sitting there to be able to call and testify and say, well, what she actually said was this. So that's really the mistake. It's just bad practice not to have someone around. But disqualification for what happened here is pretty unlikely. Did I find the prosecutor's argument compelling? I really didn't, but I think the law is going to be on their side.
All right, Kurt, let's see if you're right. Let's hear how Judge Glanville ruled right now.
The communications by telephone at various times in States 35 Alpha Alpha as it relates to Ms. Love and the witness, Ms. Bennett. The court in reviewing those doesn't find anything that would be other than the one advocate's attempts to seek scheduling and pleasantries with the witness. And for those reasons and applying Bonner and the other cases that the court has cited for purposes of this analysis, I'm going to deny the defense's motion to disqualify Ms. Love.
Okay, there you have the judge's ruling. Kurt called it. Alexis, I want to get your take. Do you think the judge had it right based on the arguments from the attorneys in court?
Yeah, no surprise here. I mean, no surprise. It's highly, highly unusual to disqualify a prosecutor. Although I do believe this prosecutor does need to cross her, T's and dot her I's, because, I mean, there are some things here that are a little questionable about how she's handling certain things.
No, absolutely. And Kurt, both you and I are former prosecutors. And, when you have a case that you are prosecuting, especially a very important case or a large case, and this is a RICO case, it's sometimes easy to get close to witnesses, easy to get close to the victims in a case, but you always have to be mindful as to what you are doing and what you are saying, certainly what you're putting in a text or an email when it becomes discoverable. Kurt, do you think that the prosecutor could have done something differently here so this issue would not have been raised?
Yeah, I think so. I mean, it's always difficult. Like you just said, you start to get very, very intertwined and personally involved in the case, and you want it to go well. You get to know the witnesses, especially in a case like this that lasts that long. So it's easy to make mistakes and become too friendly, like it sounds like this might have happened here. Being a prosecutor is a difficult job, and a case like this makes it even more difficult because it is so voluminous. So you have to quote Alexis, cross your T's and dot your I's. She has to be very careful going forward. But again, I think the judge made the right call here, and disqualification was not the appropriate remedy.
I agree. And Kurt Altman, thank you for joining me and Law and Crime. Your analysis was great. You're going to be signing off at the top of the hour. Alexis, you're staying with me. We're going to take a quick break here at Law and Crime. When we come back, we'll have more live trial coverage, so stay tuned here at Law and Crime.